thoughts build up until I can't hear, that my mind fills up into a creature, and it haunts me somewhere much deeper. Hey guys, welcome to the pre-trial hearing of Alec Baldwin, and we are going to go straight to it from here.
Prepare for their testimony is completely proper, and we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
There you are.
All right. Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says, this is what I said. I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up. And this happened in the Hannah Gutierrez trial. So
this judge is no nonsense.
I don't have any intention of approaching during the trial other than the rarest of circumstances.
No. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay, I have to internalize this.
I have to internalize this. Wow, okay. It's not that hard to internalize. You've just been told something. But what the judge is doing is trying to strip the trial of possible pageantry and posturing. And you can imagine with a client like Alec Baldwin, there will be plenty of both if you don't take charge of it. And so she's taking charge of her courtroom. And you can see the defense doesn't like it. Quite interesting, Alec Baldwin's appearance. He's wearing glasses that you can clearly see. It's not like they're understated glasses. They're kind of overstated glasses. He kind of looks a bit like a nerd, like, the kid in class who is the bookworm, right? Is that actually how Alec Baldwin presents himself otherwise? Is that how Alec Baldwin presents himself in the movie Rust? Anyway, let's continue.
I've never had a trial conducted that way, so I would ask that potentially...
Does the sound okay, guys?
I don't think the defense or anything that I've done.
Look at Alec Baldwin's body language, already not appreciating this, doesn't like being told what to do. Alec Baldwin is usually the king of the castle wherever he is. He doesn't like this move, does he?
Done would necessitate changing the rules. At least I would ask that
this is a court can do what they want with respect to objections, and this is what I'm going to rule. So I'm trying to the sides have been contentious with one another. I think.
So that's quite important background, is that she's saying there's been a lot of argy-bargy. By the way, Alec Baldwin has been brought to trial kicking and screaming. It's not like he's here and I'm happy to be in court. He's put in so many motions to have the case dismissed. There's been a lot going on over the past 2-3 years. And here he is. And so the judge is really trying to tighten the screws. Let's have a trial, a proper trial, and not like a kangaroo court kind of thing. Let's not have an episode for TV or the movies. Let's have the court take place inside the courtroom.
That you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury, and you're going.
So you can see there, it's this idea, she's trying to limit the influence of the jury, but basically influencing the jury in a mischievous way, right? In a way that is, think about the whole Karen Reid trial, which I'm sure this judge was watching. Like, how do you prevent a trial from devolving into a circus? Well, don't allow what happened in the Karen Reid trial. So take charge of your courtroom. That's exactly what she's doing. Don't allow the lawyers to posture and dance and make their sort of speeches. Keep that side of it limited, right? Thanks very much, Fatigus. Appreciate it.
Object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
And may I just approach for just
Yes.
a second? So I'm glad I saved my rebuttal because I do want to address this issue, Your Honor. What I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and disrupt the defense. It is not, as I think the court will acknowledge, it is true, the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have.
Now, you may remember in Depp versus Heard how Sanchez, it was Sanchez, right? How she was like on that trigger. Every fourth word, objection, Your Honor, objection, Your Honor, objection, Your Honor. And it's quite interesting how he's saying, well, we don't want to have the defense disrupted. Well, I think what's really going on is what they want to do is disrupt the prosecution. A lot of a trial is about momentum and disrupting momentum, because you get enough of your story in, the jury get a sense of, wow, is that what is going on? And of course, if you can disrupt it, you confuse the jury. And a great way to create doubt is through confusion. And a great way to create doubt is don't let the narrative be allowed to lay itself down in one go. Instead, keep disrupting it. And then it not only makes the defense look like they know what they're doing, it interferes with the narrative just being laid down, right? And that is going to create doubt in and of itself.
What I would call a normal.
But did I call her Sanchez? Sorry.
If every time
Camille Vasquez.
How
could I forget?
They're standing up and they're making everybody come to the bench. They're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us, at least, if after the first witness, even the court wants to revert to what they did later on.
It's quite strict.
Retrial. But I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it.
So a little bit of casting shade on the judge. Wow, Judge, I've never had this situation ever in my career. What do you think the judge is going to say? Wow, I'm really embarrassed by this. Okay, let's do it your way. Do you think she's going to say that?
I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way. And then the court can, like this, and not hear from me further on this issue.
I just want to respond to that. Camille's objections were almost all sustained. Why does a defense need to be so defensive if you don't really have a case? I don't really get it. Like, if all of it's not true, why do you need to object on every little point? Anyway, let's leave it at that.
Thank you.
I'm not going to change my mind. I can see what I want to do is I want to start with you all getting the lay of the land.
So we're not in Kansas anymore. We're in a Santa Fe courtroom. I've actually been to Santa Fe, and I've been to the ranch as well. Not inside the ranch, but certainly to the gate of the ranch. And it's definitely not New York. It's a totally different ball game. And so she's basically saying, in my courtroom, I'm the king, not you.
And I'm going
And look at that body language from Alec Baldwin. Things not looking so great at this point.
to be in control.
Hey, Robbie Robin.
Room. So this is what I'm going to do. I'm sorry that you haven't experienced this, because it can happen, and it does happen. So that's what I'm going to do. If you all seem to be.
What do you think Alec Baldwin's actually writing down? I mean, the judge is simply saying you're not going to object repeatedly. You're going to do it. You're going to have to come up and do it with me, and we'll put it on the record. What do you think Alec Baldwin's writing down? I mean, it's quite simple.
Doing well.
Is his pen actually even moving?
And you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay? All right. So, I don't know what I basically
Come on.
didn't really rule, except that I'm in control of the courtroom. All right, thank you. All right, next up is state's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but this case isn't about the medical issues of Ms. Hutchins, and we're going to address these issues in another note.
What is the bottom line? You are no objection?
No objection, Your Honor.
All right.
So what is quite interesting with the medical situation of Helena, by the way, that's Helena behind me, is this idea that did Alec Baldwin kill her, or did the bullet that penetrated her body, pierced her body, did that kill her, or did she have some pre-existing health problem? And that's the issue. That could be one pretty cynical argument from the defense, but another one could be, did the emergency medical service worker, the person, the paramedic, for the lack of a better word, did they botch the treatment of Helena? And I can't remember, I think it's intubation, but they basically made some error where they I think they intubated her through. Anyway, there was some difficulty there. They had difficulty stopping the blood loss. They had difficulty, I think, getting I'm not sure if it's a tube so that she could breathe. But if you think about it, I didn't kill her. The medical personnel did, because they botched trying to save her. And if you think about it, does that make sense? Someone is shot point blank, and then you say, I didn't kill her. She didn't die because of the bullet. She died because of the medical treatment. And in a way, certainly if you're a big fan of Alec Baldwin, you can say that makes absolute sense. She was shot with a bullet. That's not a big deal. The problem was the idiot that was taking charge of her. And that's certainly one interesting aspect from the defense, that who knows what the jury will make of that.
All right, no objection. Let me just write this down.
That's right. It does look different, right? He's writing quite a lot, taking quite a few notes. There, Baldwin looks straight at the camera. He knows he's on camera.
Defendant's motion limine number 2 to preclude inadmissible character and prior evidence and statements unrelated to the events of October 21, 2021.
Good morning, Your Honor. It's nice to finally see you in person. Thank you. So I'll be brief. You just heard Ms. Johnson.
So you see, this lawyer's got a bit of a bedside manner, smiles at the judge, nice to see you, because the other one hasn't really gotten off to a very good start. And so maybe good cop, bad cop a little bit here, right?
In response to our arguments about the civil suits, say the civil cases are about October 6th to October 21st, the whole negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore.
Now, what's quite interesting behind him, this attorney, I'm not actually sure what his name is, but he's actually on his phone at this point. It's quite weird. He's like in the middle of a pre-trial and it looks like he's on his phone.
On set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must.
What do you think? Is that a good look? He's behind his co-counsel sending some kind of text message. Is that a good look?
Be excluded, Your Honor. The state cites 3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The U.S. v. Reggio case. They say Reggio was a commercial trucking driver, and the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured.
Excuse me, how is someone not injured? I'm not sure if I'm following.
Because he swore at someone on the 16th or threw a gun on the ground on the 16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite 2 other cases, the Coughlin Lambert cases. Coughlin, they say, the court allowed the government.
So he's basically saying what Baldwin did wrong on the 16th was he swore. I don't think that's what he did wrong. He also pointed the firearm at someone. So really, I think that's a little bit mischievous to say Baldwin swore at someone. That's what he did wrong. That's not, I don't know. It's a little mischievous, I think.
To introduce evidence of his prior athletic activities when he had submitted
I
a
did see
victim's
that.
compensation claim after being injured at 9/11.
I saw that.
See, look, prior activities, case now about a fraudulent claim, 9/11. But the fraudulent claim charge against him was that he wasn't actually injured at 9/11 as severely as he said he was. Because look at, he's running around, he's an athlete. He's clearly not injured. So it had nothing to do with propensity, had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case, the bank robbery case.
So this lawyer in the background is, again, on his phone. I don't know whether he thinks that he's not on camera because he's in front of him.
The defendant was talking about robbing a bank before, planning the locations, plotting it out. And then lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence.
Is that it? I think that is it. So that was basically the pre-trial hearing. I don't know if there's any more than that. but yeah, the judge has definitely taken charge of her courtroom. Good for her. And so, yeah, I just want to see what we have here. Just continue.
Witnesses are going to testify that the defendant was the boss on set. And Your Honor, with
Yeah, and that's so important to say. While he was swearing at someone, that's not so bad. He was actually the boss on set. So the boss on set swearing at people. He's also setting an example to the other actors and so on. Anyway, let's hear what she says.
regard to what this is relevant to, it's relevant to his recklessness, because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore, on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer, and pulling that trigger is reckless conduct. And so I think that both sides quoted the producer agreement. There are no limitations to this producer agreement. And it goes to the issue of the defendant's reckless state of mind. And Your Honor, I just wanted to briefly address something that I think was relevant to the
Tell me what the safety bulletin says that the producer, you're referring to bulletin number 1. What are you relying on?
Well, there are a number of requirements as it relates to firearms, that the actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set, that they are to treat a firearm as though it's always loaded. Do not point a firearm at another person. That is also, it's for the
Again, look at Alec Baldwin's body language. He's got his arms folded. He's definitely not a happy camper.
It's for both, Your Honor. These are set safety.
You must get the sense that he's trying not to fold his arms. He's just unfolded his arms again. It's almost like he's trying to not, be himself in a way.
The rules.
So what about? So you're not even relying on that.
There he's folded his arms again.
We are, Your Honor.
In your response, you said that you weren't talking about the SAE guidelines. You were talking about New Mexico law.
Well, Your Honor,
I just want to quickly deal with this question. Was the incident not filmed? Just before the incident was filmed. Obviously, the incident itself was not filmed, but just before it was filmed, and you can clearly see kind of what's going on there. You can see that his finger is within the trigger guard, and that kind of thing. Also, it wasn't in the script for him to pull the trigger.
I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that? We prove that by demonstrating his conduct, not just on October 21st, but in the days leading up, that by violating these on-set movie set rules, that his conduct was reckless. Because it's not reckless.
Now, I must say, in the long run up to this trial, but I remember especially early on, people were saying, it's not the actor's responsibility to do this. It's not the actor's responsibility to do that. And it's like, do you know what the protocols are on a movie set? It's not the actor's responsibility. It's not, and you can say it over and over and over again. Well, there are actually rules conducting the behavior of actors on a movie set where there are firearms. And this wasn't just a one little firearm movie set. This was lots of firearms. I can't remember what the exact number was, but this is a cowboy movie, so there's unusual amounts of firearms and also unusual firearms. The firearms are kind of vintage. They're unusual as well, and firearms are being used in multiple scenes, unlike some movies where they come out in a specific scene and you don't see them again for a while. I'm just trying to think of, like, the movie Kill Bill. How many times do you see a firearm in that film? It's not a cowboy movie. think about this movie or cowboy movie, the meat and potatoes of the film is, gunslinging and scenes with a firearm. And so obviously there are rules that govern that, and that those rules apply not only to the actors but also to the crew and also to the producers. So they're kind of like three dimensions to it. The actor, the crew, of course, Baldwin's not part of the crew, but you would imagine that he has some say as a producer over the crew, one would imagine. I do remember during his interview with ABC, he said the hiring of Hannah Gutierrez had nothing to do with him. His job was to look at the script and I guess the creative side. If this is your baby, like he was this was a movie starring him. He was the eponymous character. He was, I think, one of the major funders of the film. Are you really not going to know anything about hiring choices? Does Baldwin seem like the kind of guy who wouldn't know about everything, or who wouldn't want to know about everything?
Recklessness in a vacuum from
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's what I wanted to address. There are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin, as a producer, should be aware of all of the safety regulations.
Okay, so I did have trouble wrapping my head around this, as you can tell, okay?
I understand.
So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It goes to, Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role.
Yeah.
And with both roles, he fails in maintaining the safety of other people.
That's really important. He doesn't only fail in one role, he arguably fails in both roles. It's not only the actor's responsibility, it's his responsibility as a producer.
See, what the defense is trying to do is just basically pigeonhole Mr. Baldwin as just an actor who...
Absolutely. So they're trying to say he's just an actor, he doesn't have any, he's like the small little person, and, he doesn't really have a big responsibility here. And Baldwin himself was saying, I do what the director tells me to do, and I do what the cinematographer tells me to do, and I'm just kind of like this passive person. Just tell me what to do, and then you kind of got to go. But we're dealing with Alec Baldwin. Is he the kind of guy who, please tell me what to do, or is he the kind of guy who tells everybody what to do? And we've got footage in from the movie Rust showing Baldwin being Baldwin, and is he playing the passive, tell me what to do person?
Relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer, well, I understand, Your Honor, but if the court allows the expert testimony, the state will present evidence that the defendant had.
So before I forget, I just want to bring up something that happened in the Hannah Gutierrez Reed trial that was fascinating. And I really think if there's any doubt about guilt and any doubt about which way the court was going, and any doubt at all, it was all about gun safety, and you had the armorer talking about gun safety and so on. And then you actually had a defense witness come in and basically wave a gun around and basically also gesture with the gun. And the judge actually stopped him and said, you know what? You haven't even checked that gun and you've already pointed it at me. And, it was kind of like the court had been educated on gun safety. I'm not saying from scratch, but just that in terms of this case and in terms of what had happened, like you bring a gun into a room, first of all, make sure it's safe. Second of all, whatever. The judge actually had to admonish the defense's witness to say, hey, stop waving the gun around. You haven't made it safe, and stop pointing it around, etc., etc. And in a way, in that moment, the case was made for what not to do and what the protocols are and how these accidents can happen. I mean, being reckless with a gun isn't really an accident. It's an accident waiting to happen, and an accident waiting to happen isn't an accident. And so I think if there was any moment where the jury needed it to be made explicit why you need to be careful, that was the moment. And that actually happened during the trial. Just a pretty incredible moment. Do you guys remember that?
Not just his role as an actor, but as a producer, it's heightened in the sense that he is supposed to be aware of the regulations, of the safety, and that's the most important thing.
I'm just having trouble with this. Okay, I don't understand how you're going to say as a producer you shouldn't have.
Sorry to interrupt there. I don't know if I agree with that on Thierry. Baldwin has been in multiple projects since this has taken place, so I don't know. I don't know if that's going to be the case. In fact, I think they've just greenlit reality TV series like the Kardashians on his family.
Shouldn't have, as an actor and a producer, he shouldn't have rushed. He shouldn't have said, quick, move.
Well, but
Yeah.
so as an actor, of course, he shouldn't have done that. But also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness, that he essentially, as the boss, failed the people who worked around him. And it gives him the power to control the safety. So as the producer, he has the power to control.
Yeah, and so that's such a good point. He has the power, right? He has the power, and that's kind of been what he's been trying to say. He doesn't have any power. He does what he's told, etc. And she's making the case he does have power. He has extraordinary power as a lead actor, as a multimillionaire, as a well-known celebrity, Alec Baldwin, and then also as the producer.
Safety on set. And there was a tremendous lack of safety on this set. And so as the boss, he's emboldened to do whatever he wants to do. So this goes to the willfulness that the state has to prove.
Producer to do whatever he wants to do.
Because you're going to hear testimony from witnesses, if the court allows this, who will say he was the boss, he was calling the shots, he would rush people because without regard.
Maybe that's his personality as an actor.
Well, but that's irrelevant, Your Honor. With regard to his role as a producer, he has responsibilities, and he has a responsibility to maintain the safety of the set. Whereas an actor, perhaps those may be lessened, but as a producer, those are heightened. And so it's relevant to demonstrate his willfulness, the willfulness of his conduct, that on October 21st, he once again disregarded the safety of Ms. Hutchins and Mr. Souza and pointed that gun directly at Ms. Hutchins. And so that is why this is relevant. We can't look at this in a vacuum. And in fact, the court in State versus Duncan noted that relevance does not exist in a vacuum. Instead, it's the logical relationship between evidence and a proposition and issue that the party seeks to prove. We have to prove willfulness. We have to prove recklessness. So in order to do that, the fact that he was a producer and the boss is absolutely relevant.
Let me ask you something. So in the involuntary manslaughter, with respect to the first negligent use of a deadly weapon, okay, that's not the producer, that's the actor.
That is the actor, but he's also charged in the alternative.
The alternative, that he failed to check the gun.
It's more than that.
Well, that is what was given to the grand jury, that he failed to check the gun and pointed a loaded gun at a person. That's what it was in the grand jury. So you want the producer you want to introduce that he was the producer and what he was required to do to be able to prove that alternative theory that he was supposed to check the gun.
Well, and that he wasn't supposed to point it at another human being and to pull the trigger. And so, and as a producer,
How does this role as producer, that as a producer, he wasn't supposed to do that?
well, his role as a producer goes to what he is required to know when it comes to safety of others.
That's quite important, what is required to know. So the producer has a higher responsibility, the person managing the set, the person running the set, really, than the actor.
He has a responsibility to ensure the safety of other people. So it goes to the issue of his willfulness, that on October 21st, when he points that gun at Ms. Hutchins, he should know that as a producer, he's responsible
Well
for her
said.
safety, because that is one of the things that producers are responsible for, safety on set. And so the fact that there was a lack of safety on this set, Mr. Baldwin should have known that by his action of what he did, moments leading up to the shooting of Ms. Hutchins, essentially show a willful disregard for his safety and recklessness. So it's not a theory of prosecution, it is evidence that goes to prove an element of the offense. And we would respectfully ask that the court allow the introduction of the fact that he was a producer, and that as a producer, he has obligations to ensure the safety of others.
And who's going to be your expert witness on that?
May I have a moment, Your Honor, to confirm?
Not looking too happy. I mean, look at her face. Not going well so far, is it?
So we have two witnesses, Mr. Carpenter, who testified before the grand jury. In fact, he testified about the producer role. And then Kent Jorgensen, who is one of the individuals involved in drafting and updating the safety bulletins for onset safety.
Know that Brian Carpenter was not an expert.
Yeah, so just to note that after the incident, Jensen Ackles, someone asked him, do you check? Because I think Alec Baldwin was saying, I don't check, it's not my, I shouldn't be the last line of defense. And Jensen Ackles said he would normally just fire the gun into the ground immediately prior to using it. And he said it takes 5 seconds. And the armorers don't really like that, because they say you can strip away the gears or whatever, but he does it anyway. And so that was the way he did it. A very quick, simple way of making the gun safe, easy. And that was what he said he habitually did. I don't know if you remember, George Clooney weighed in and said, wow, he gave his opinion disagreeing with what Baldwin had said. I think Nicolas Cage also weighed in at the time.
Admitted as a producer in Hannah Gutierrez. He was a firearm expert, and he has not been admitted as an expert because there was no judge to get him to be an expert at the grand jury. So he has not, at this point, been admitted as an expert as a producer.
Right, and we would tender him. Obviously, the court will have to do its gatekeeping duty and role. Mr. Jorgensen, however, and in fact, I think there's a motion pending about Mr. Jorgensen, but Mr. Jorgensen is also an expert on this. He's familiar with what the safety guidelines require of producers and of actors. And so these are germane issues that the state is required to prove, and we'd ask that the court allow the state to introduce this evidence.
Thank you.
Your Honor, I hardly know where to begin, because I honestly don't understand the theory or the facts that they intend to articulate to demonstrate that on October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. They said Well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins weren't violated. New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure your honors read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors.
I must say, I agree with that. It's like, oh, really? Are they supposed to say, oh, it's ridiculous.
Armorers, the first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and there, as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was. But you just excluded the evidence of him rushing because that's propensity evidence. That's inappropriate. The fact that we're so confused about what the theory actually is goes directly to the prejudice that will far outweigh the probative nature of this testimony. And we'll get into Mr. Jorgensen and Mr. Carpenter later, unless your honor wants to hear about why they are not qualified to testify as experts on producers. I'm sure we can push that on. But the reality is this will confuse the jury. This will be highly prejudicial. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed
So
involuntary.
if you think about it in a sensible way, a common sense way, when is Baldwin the producer and when is he the actor? And I think it's quite simple. When he's actually acting, he's the actor. Like when the camera's on him and the cameras are rolling, he's the actor, right? Does that make sense? I mean, I don't know how to be more explicit than that. When you see him basically calling the shots, literally saying, let's do this again. Okay, you go over there, you on that side. Is he then the actor? Isn't he actually the producer then? Because a mere actor would never act in that way, would never be telling the cinematographer what to do. If you try and imagine one of the other actors doing that, you just can't imagine it. So when he's actually being filmed, he's the actor. I'm talking about when the cameras are rolling, then he's the actor. When it stops rolling, then you can add that producer role as well.
Manslaughter, that is highly prejudicial, inappropriate evidence, should be excluded.
All right, so what I think is more appropriate is I'm going to revisit this, make my ruling, no more argument on it, but I think that we should do
I wonder what this is over here.
Mr. Well, you didn't raise, Mr. Carpenter, except duplicative testimony.
So, yeah, well, that's quite an interesting point, duplicative testimony. What's quite interesting with Dave Halls, he was the first AD, first assistant director. He actually took a plea deal, and otherwise I think he could have been in some trouble. And I think Sarah Zachary also made some kind of deal. So two people on that set, I think, took deals and got some kind of immunity. Interesting.
And
No, that's just the cumulative expert test motion. Your Honor, that's correct. We raised Jorgensen.
right,
If you want to do Jorgensen now, I'm
Right.
happy to come back up and talk about Jorgensen.
all right, let's do Jorgensen.
Okay.
Baldwin's writing down
The
quite a
state
few
intends
notes.
to offer Mr. Jorgensen on two issues. One is the role of a producer in managing the safety of the set. And the second is the safety bulletins that govern actors on movie sets. Mr. Jorgensen should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgensen has never been a producer in his life. He was a camera grip back 25, 30 years ago, never been a producer. We asked him, what is the basis for your testimony as to what producers know what their obligations are on a movie set. He said, well, it's because I get to sit at the kids' table, these are his words, and listen to the adults talking. Your Honor, this is not the kids' table. This is the adults' table. Mr. Jorgensen has absolutely no expertise, and sitting at the kids' table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter, number one. With respect to the safety standards, Mr. Jorgensen didn't draft the safety standards. He's not a gun expert. He was a camera grip, sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armor. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative. They want to draft safety guidelines. Mr. Jorgensen says, I'm going to go find gun experts. I'm going to delegate the drafting of safety bulletins to gun experts. They're going to draft it, not Jorgensen. The gun experts are. And then the gun experts are going to send it back, and Jorgensen wordsmiths and edits. But it's the gun experts who determine gun safety standards on movie sets, not Mr. Jorgensen. He has no basis to offer an expert opinion about gun safety standards, what the standards mean, how they're supposed to apply, because he didn't draft them. He's not the expert. He doesn't know anything about them other than how they got drafted. But how they got drafted is not an issue in this case. His evidence, his opinions should be excluded.
Your Honor, Mr. Jorgensen teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience, the position that he holds that allows him, that puts him in the position where he teaches producers about set safety. So I want to be clear. I am not calling Mr. Jorgensen so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. So we've got that as the first issue. Mr. Jorgensen is indeed one of the people who drafts the safety bulletins. I'm not sure where the confusion came in. Mr. Jorgensen is the chairman of the, it's on the tip of my tongue, the industry-wide labor relations. It's on my computer. My apologies. So in that role, what Mr. Jorgensen does is, here's how it works. Representatives from all of the different film unions come together. So we've got somebody from the Directors Guild and somebody from the Producers Guild and somebody from IATSE, and that's who Mr. Jorgensen is. They all get together and they agree and draft these safety bulletins. Mr. Jorgensen is one of those people who sits at the table who drafts these safety bulletins. So his testimony is entirely relevant, one, because he actually drafts the rules that Mr. Baldwin is required to follow, whether we're talking about him as a producer or an actor or anything. And number two, Mr. Jorgensen sits with people from the Producers Guild of America to sit and discuss these safety bulletins and whose responsibility is what, in addition to teaching producers how to do this. So I think that his testimony is absolutely relevant with regard to, these are the safety bulletins. He lays a foundation for the safety bulletins. These are how the safety bulletins are created. This is a safety bulletin. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed. Those are the safety bulletins that Mr. Jorgensen participates in developing. So his testimony is wholly relevant. Now, whether or not the court decides that Mr. Jorgensen's testimony with regard to a producer's responsibility as it goes to set safety is something that I think the court has indicated that you may want to reserve ruling on until you see and experience how the trial is unfolding. But there's no question.
Have you noticed already when you hear the defense attorneys, you're like, wow, that doesn't make any sense. And then you get a bit more perspective from the prosecutor. Can you see just in this, he's sort of like, wow, what's that all about? This guy's got no experience. Oh, he teaches that. Oh, okay.
That Mr. Jorgensen gets to come in and testify about the safety bulletins that he himself participates in drafting. Thank you.
Just a few points, Your Honor. The fact that Mr. Jorgensen is allowed to teach at some university about how people shouldn't get sued in civil cases, it doesn't make him an expert in this court. He's never been a producer. He's not an expert in being a producer. The kids' table doesn't allow him to sit at the adults' table, period, full stop. He also is not a gun expert. Didn't draft it. They're going to have Mr. Carpenter come and testify about safety standards with respect to using the weapon, pointing it, not pointing it. Now they want a cumulative expert, Mr. Jorgensen, who doesn't actually develop the guidelines. He's not the gun expert. He admitted that. He doesn't develop the standards. He said, I hire gun experts to draft those standards. They're going to have two experts, one of whom clearly not qualified on gun safety, Mr. Jorgensen, testify, and then put Carpenter in too. This is a day of testimony of cross. We already have a short schedule, Your Honor. You should limit this testimony. He's not qualified to give opinions on these issues.
Thank you. The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the SAG guidelines say, but he has no qualifications to opine on what a producer does. I
think that's fair. I hope the prosecution can get a producer, and one wonders whether the prosecution may have difficulty finding a producer is going to I don't want to say testify against Alec Baldwin, but basically that is what he's going to do. And is that committing a kind of career, shooting yourself in the foot in this case? Or are you going to have some Hollywood producer testify against a big star? Are they going to be able to find someone?
He doesn't know how a producer implements those guidelines. So, he can say these are the guidelines. But
I just want to deal with this question. If they prosecuted the armorer for negligence, what are they prosecuting Baldwin with? Negligence.
But he needs to be a producer to say, this, as a producer, this is how I meet these requirements. The other thing noteworthy about Mr. Jorgensen is that based upon his pretrial interview, which is what would have been the time to let the state know, the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on whether what Mr. Baldwin did as a producer was good or bad. All right, I'm going to revisit the producer. I'm going to make the following finding. I'm having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Helena Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin, individually as an actor, committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory.
So it seems like the judge is basically saying, let's keep things simple. As an actor, what did he do?
The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer.
I hope that's not like an absolute thing, because that's, to me, strange, because he was a producer. He had additional responsibility as a producer. So that to me is not very, that's a bit strange.
All right, shall we continue? All right, so we're going to the states now. That was
It did sound pretty absolute.
Baldwin's motion. We have Jorgensen, we finished?
Yeah.
All right. Defendant State's motion eliminating number 6 to preclude accusations of prosecutorial misconduct.
Your Honor, unfortunately in this case, or this case has been fraught with numerous accusations of prosecutorial misconduct. And they were raised in the context of motions to dismiss for constitutional violations. They were raised in the context of motions to dismiss the grand jury indictment. The court has ruled on those. Those allegations were perhaps relevant to those legal motions, but they're not relevant to what the jury is required to find. So I would respectfully submit, Your Honor, that the court preclude the defense from making arguments to the jury about and that would be the main issue I would submit to the court, that the defense would be introducing this. And I noted on page 4 of the motion the allegations, for example, that obviously the jury's going to hear about the accidental discharge test that resulted in the damage to 2 internal components of that firearm. But to argue to the jury that resulted in...
So, you know what the accidental discharge test was? I think they did something like hit the weapon repeatedly with a hammer or a mallet, and then to say after that, wow, you've damaged the weapon, so now the weapon is kind of you can't use it as an exhibit. Such a
constitutional violation to the defendant's rights is improper. The court has ruled on that motion. There have been numerous allegations of discovery violations and disclosures, and that they were designed to prevent the defendant from receiving a fair trial. Again, those are legal issues that the court is going to be deciding and has decided and have no place before the jury. That the prosecution conspired with law enforcement to intentionally damage this firearm, again, that went to the Trombetta motion that the court has already ruled on. there's another issue that there was a meeting you heard about in the motion hearing that Mr. Haig, Lucian Haig, had a virtual meeting with Mr. Ziegler from the FBI where counsel were present. And during that meeting, he asked Mr. Ziegler how he conducted the accidental discharge test. Now, while that is a proper area of inquiry for cross-examination, any implication that that was improper or unethical should be precluded, because under Rule 703, experts can confer with other experts in forming their final opinion. And there's nothing wrong with that. And so I had to bring this motion to the court, Your Honor, because I am concerned that there will be, throughout this trial, numerous allegations that the state has engaged in misconduct and trying to deprive the defendant of his right to a fair trial, and those have no place before the jury, and we'd ask that the court preclude that.
So the real criminal in this case is the prosecution. It's a witch hunt. The prosecutors have got a bone to pick against Alec Baldwin. The prosecutors are biased. The prosecutors are spiteful, right? The real criminal here, the real people who shot Alina Hutchins, are the prosecutors. And Alec Baldwin is the innocent victim here. For some other reason, the prosecutors have like this, or out to get him because he's a big, powerful movie star, and the prosecutors want their time in the sun. Except, why would they go after Hannah Gutierrez-Reed? She doesn't have any of those things. She's an unknown person with no money or influence. Maybe the prosecutors just want to prosecute this case.
Let me just be clear about what we intend to do and what we don't intend to do. This is not going to be a trial about the ethics of the prosecutors. It's not going to be a trial about they should have dismissed the case a long time ago. They did.
Do you notice now he's folding his arms about the ethics of the prosecutors? Do you think this should be about the ethics of the prosecutors or the ethics of the defense? What did the prosecutors do wrong? Try and prosecute this case?
They took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation. We're allowed to attack the credibility of witnesses as it relates to the government investigation. For example, Your Honor already ruled that with respect to that meeting between Mr. Ziegler and Mr. Haig, that gets to be disclosed to the jury. In fact, the prosecutors are required to disclose it to the jury, you ruled. And so all of that goes back to the black letter law that we started with on that prior motion in limine.
So just a quick reminder, when Alec Baldwin gave his first interview, and I hope that would be played. Somehow I think it's not going to be, but he thought, did she faint? In other words, he fired the gun, or the gun discharged in his hand, and the bullet went right through poor Alina's body, went in the one side under her armpit, came out the other side, I think by her shoulder, then went out and penetrated and hit the director in the shoulder. And he was like screaming in agony, and they had to get the slug out of his shoulder after that. They're telling me the projectile, with the force that it came out of the firearm, didn't give Baldwin a sense, wow, that was a live round already. And he was like, I thought, well, did you faint? Right? As you say, the recoil and the loudness should have told him instantly what had happened.
Okay. We're allowed to demonstrate the bias, the incompetence, the improper motivations. We're allowed to attack credibility. We're allowed to attack the fact that the FBI destroyed this gun, et cetera, et cetera, et cetera. All of those issues are fair game Hornbook law. We intend to introduce that. The state shouldn't be allowed to preclude it. have nothing further, Your Honor. It's black letter law.
Thank you. Any reply?
Thanks, Pauline.
Just briefly, Your Honor, I think we may be in agreement. What the reason for this motion was essentially to preclude the defense from essentially making personal attacks and allegations of prosecutorial misconduct. We agree, and we will present evidence about the Ziegler-Hague virtual meeting, about the gun. But we just ask, given the contentious nature of this case so far, that we focus on the evidence and not on allegations, personal allegations and attacks during this trial.
So one wonders whether Alec Baldwin's whole family are going to be in court. You know, he's got something like 8 children. Are they going to be in court cheerleading their dad? One wonders whether that's going to be part of this, part of the optics of this trial.
All right, thank you. The court rules and reasons. The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing issues. However, to the extent that the defense may elicit evidence about the Santa Fe County's investigation, the FBI testing, the Hague's 3 reports, and his meeting with Ziegler, this evidence is relevant as it makes a fact more or less probable, and the fact is of consequence in the action, and weighing it, the probative value of the evidence is substantially outweighed by danger of unfair prejudice, etc. All right. Thank you. Now we're going to, let me just back up and do these 2 that. State's motion in limine number 4. Let me just.
Are children allowed in court? I don't actually know.
State's motion in limine number 4, which is no
I've never
reference to the
seen
potential
children in
punishment
court
in the
ever.
case.
There's no issue.
Good
All
point.
right, so that's agreed, stipulated. State's motion limiting number 5 to prohibit the defense from arguing to the jury examples of the definition of reasonable doubt.
No present intention to do so. I know we'll discuss reasonable doubt, but those random hypotheticals, I don't think the court should preclude the defense from arguing anything that they.
George, I don't think it's I don't think the issue is so much that he failed in his duties as a prosecutor, as a producer, but that he failed in his duties as an actor.
Do what you decide the law as long as it's relevant, but we have no present intention.
You're not going to give him an example of reasonable doubt, okay?
Yeah, I have no present intention to do that.
Okay, and that doesn't come up, and that doesn't come up in voir dire either. Okay.
So, do you think that Baldwin is going to testify? And do you think that Baldwin should testify? I think I'm going to put that up as a poll. I think I'm. So it's basically, let's just put it up quickly. It's going to be a yes or no poll. Do you think Baldwin is going to testify? And do you think he should? So I'm actually going to make it yes and yes options. Yes and no. No and no and yes. And no and no. I'm actually getting confused by this question. I think there's all the options. See what you guys say. Should he remember, Hannah Gutierrez-Reed didn't testify. Should Baldwin testify? Do you think his lawyers will tell him not to, and he will? Should he? Shouldn't he? What do you guys think?
All right, where are we? We've got defendant's motion in limine number 4 to preclude improper expert testimony from lay witnesses.
Thank you, Your Honor. The state wants to admit evidence from the camera grip, for example, about how dummies are made, safety standards for armors on set, safety standards for producers, etc., the camera grip. It wants to have the medic testify about the standards for armorers on set. This is improper opinion testimony that can only be given by an expert, not by a lay witness. The state cites the State versus Vargas case, Your Honor. They say it's a two-part test. Part number 1 is, can the lay witness testify about it based on personal observation? Part number 2, can the lay witness rationally connect their personal observation to the opinion testimony? They say they can, because the medic has been on movie sets, it's personal observation. What the state overlooks is that before Vargas states that two-part test, it actually addresses a third one. That's the third prong of Rule 701, which says a lay witness cannot give testimony if it's within scientific, technical, or specialized knowledge. So Vargas says, testifying about movie standards, safety standards, armor standards, how dummies are made, the things that the camera grip and the medic, they want them to testify about, are within the specialized knowledge of someone on a movie set. As Vargas put it, it has to be only within the common experience and knowledge of a lay person. Now, how do we know that that testimony is not within the common experience and knowledge of a lay person? Because the state says so in its other motions. And I brought my notes up here so I can get the language exactly right. In one of its in limine motions, with respect to the cumulative expert testimony, that's motion in limine number 8, here's what the state says. Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgensen motion that we just went over, Your Honor, let me read from that one too. Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge. They try to admit Mr. Carpenter's testimony on that too. They say this is specialized knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun.
So Tim says, I don't think he should testify. Tim, did you watch his ABC interview? I'm not sure if that's a good example, but he certainly presented his argument in quite a compelling way. When I say compelling, I mean a forceful way, an assertive way. I think there definitely were people who didn't think critically about what he said and were swayed by what he said. He is an actor, he is influential, he is likable, he is charming, he is, what's the word? He is influential, he is good at manipulating. I mean, that's what actors do. They manipulate you. They get some kind of reaction out of you. So, you know, he just needs to get one juror on his side.
how it was used, how it was made, etc. And the court allowed that at the trial level. The defendant said that's lay opinion testimony. That doesn't satisfy that third prong. It has to be tested under Rule 702. The appellate court said, you're right, reverse conviction. That was an expert testifying because the average and common experience is not that of a detective. And so it had to go through the gateway of 702. The state has not offered, has not disclosed Ms. Schaefer, Mr. Looper, or any of the other witnesses on this set as expert witnesses. They never made that expert disclosure. And to the extent they did, we would have obviously filed an eliminate motion to exclude them as experts. They weren't offered as one, so we filed it this way, as experts, because the medic doesn't have the expertise to testify about armor standards, or the camera grip doesn't have the expertise to testify about movie production requirements. We just went through that with Jorgensen. And so this is lay opinion testimony that violates Rule 701, that has not been offered under 702 or met the guidelines of 702, and therefore any witness that they want to testify about any issue outside of what they observed on Rust, what they saw in other movie sets, what armors do on other movie sets, what actors do on other movie sets, is improper opinion testimony that should be excluded when it's offered by these lay witnesses. Thank you, Your Honor.
If I were the defense, I'd want this testimony excluded also. And let me
Nice jab. That was a nice jab there.
tell you why it's relevant. Mr. Baldwin, part of his defense, and he's made these statements repeatedly, is I had no reason to think that Hannah Gutierrez wasn't a good armorer. I had no reason to think there was a problem here. This is what he says. He called Jason Bowles' office himself and said, I never had a problem with your client. I never had a reason to think that she wasn't a stellar professional. Well, Judge, you're actually in a unique position because you sat
Great argument.
through the Gutierrez trial and you saw and heard the other people, the other crew members who worked on that set come in
We were like, wow, okay.
and say, we knew immediately this lady wasn't following the proper safety protocols. How do we know that? Because
And not to be funny, but you had the armorer with her hair dyed purple and yellow. And I don't know, it's quite hard to just explain how casual and sort of careless she seemed just in general, the way she spoke, the way she dressed, the way she was, the messy way that she was kind of doing everything.
because Ross Adiego has worked on 60 to 100 films and TV shows. Same thing with Lane Looper. Same thing with Sherilyn Schaefer. She's the set medic. She's paying attention to what's going on with regard to safety. These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns about whether or not Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense of there was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check, even though he's a dolly grip, as though there's something wrong with being a dolly grip. Even though someone is a first assistant cameraman or a boom operator, they actually get to participate in that safety check because it is their lives that are at risk. So each and every one of these people should absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional. We're not asking them for a bunch of technical knowledge. Absolutely, I will tell the court, I am not asking any of these witnesses to come in and talk about the difference between dummy rounds and blank rounds. Absolutely not. These witnesses are coming in to talk about, in part, their safety concerns as it related to Mr. Baldwin's conduct and the conduct of Hannah Gutierrez. And we can't really separate those two out because Mr. Baldwin's defense is she was really good. I would also point the court to, this is Farner versus, I don't know if I'm going to pronounce this correctly, Pakar. This is a federal case, 562 Fed 2nd 518. The admission of the lay witness's opinion that the Pakar suspension system was improperly designed due to its failure to incorporate the safety change was affirmed by the Court of Appeals. Much like the federal courts have allowed lay opinion testimony based on the witness's particular knowledge gained from their employment experiences, keeping in mind this is their workplace, so too should this court. There's a case right on point. Thank you.
Few issues, Your Honor. I'll talk about the cases first, and we'll go back to what Ms. Morrissey said she's going to try to use these witnesses for, and that's expert testimony. The Farner case, it's a design defect case. Farner was driving a truck. The truck suspension failed. There's an accident. Someone died. His widow, he did, and the person in the passenger seat. His widow sued the company that built the truck. She got a person who had driven, his name was Curtis, driven the same exact truck before. Not the same one in the accident, but the same exact make, model, etc. And he said, I drove that same truck. And you fix that design defect by wrapping these chains around the suspension. It was a design defect case where the question was, is that design defect fixable? This was an expert testimony. This was fact testimony. The same with the other cases, the Kate cites, the Valencia case, the Munoz case. Those are cases where the people worked at the company that was at issue in the fraud. And they were asked about that very company. When you worked there at the company, what'd you experience? What'd you see? That's relevant to the fraud. They didn't come in and say, I worked at some totally different company. And my experience at that different company, I'm going to apply it here. That's not at all what happened in that case. This case is Vargas, based on the experience that these witnesses had in other movies. Ms. Morrissey told you they want to say, I've been involved in 40 movies before, and applying my experience there to this one, these are the safety problems I had. Even though there's that's expert testimony, because it falls right under that third prong. And number two, it is testimony that they are not qualified to give. There's nothing wrong with being a camera grip, Your Honor. There's something wrong with being a camera grip and testifying about the safety bulletins for armors. That's exactly what 701 and 702 say. And Vargas says it's reversible to allow it to happen. I have nothing further, Your Honor. Thank you.
All right, the court makes the following ruling. A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant, as compared to what they saw on other sets, makes a fact more probable than it would be without this evidence, and the fact is of consequence in determining the action. That is criminal negligence. It's they are not going to testify about the safety bulletins. They can only testify about what they observed on set in this set and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance. Okay.
Understood.
That's
All
Dave
right.
Balls on the
Court wants
right.
to take a bathroom break. All right, let's be back here at 1:15. Okay. All right, thank you. We're in recess.
Okay, so they're in recess. Let's see if we can hop to the other side of the recess. I think we can. I thought it was like a temporary recess. Are they coming back to court today? Is it a lunch break or any of you guys know? I also have to kind of go. I've got something important I need to deal with. Okay, so we're going to be in recess here as well. Okay, see you guys a little bit later. Thanks, guys, for being here. See you guys soon.
Your Honor, if I may briefly.
Yes.
Just at the end of the last motion, you noted in passing before we broke that issues with respect to lay opinion testimony would raise relevance concerns or relevance issues. And I just wanted to get some guidance on the court from that because we anticipate, for example, the medic, as I said, camera grip. We also anticipate people testifying that a few of the other actors on set did their own safety checks, even though those actors said they didn't think it to be their duty. And so
The last part what you just said.
sure, let me approach Your Honor so you can use the lectern so you can hear me better.
Me?
Is that better, Your Honor?
Yes.
Thank you. And so at the end of the last motion, you noted that issues with respect to lay opinion testimony would raise questions of relevance. And it'd be helpful to get Your Honor's guidance on that because we anticipate the medic testifying, the camera grip testifying about issues that, for example, were not reported to Mr. Baldwin, so don't go to his state of mind, or certain witnesses testifying about what a few of the other actors did on the set with respect to checking their guns when those actors themselves said, but it's not an actor's duty. And so we want to make sure that those issues are not introduced, for example, in an opening statement when ultimately it will be proven, in our view, to be irrelevant to Mr. Baldwin's state of mind, what another actor may or may not have done under the safety guidelines, or what the medic thought about the set but kept in her head and didn't report to anybody. Obviously, that wouldn't relate to Mr. Baldwin's state of mind without the reporting, or at least there's a question about prejudice outweighing the probative value of that when it goes to state of mind. And so it'd be helpful to get Your Honor's guidance on that with respect to these issues before opening, at least. We can submit more papers if you'd like, or
No, I don't want that.
I assume not, Your Honor, but that's why I'm raising it here orally versus submitting something to you.
Okay, all right, thank you. Does the state wish to reply?
Just briefly, Your Honor. So part of the defense here is this was Hannah Gutierrez's job. This is Hannah Gutierrez's fault. The truth is, Hannah Gutierrez wasn't doing her job properly, and everybody seemed to notice it except for the defendant. So it's true. We do intend to have witnesses say, I had concerns about the way that firearm safety was being conducted on set. In terms of whether or not it's relevant that other actors perform their own safety checks, I think probably just depends on how the evidence develops. I think my very first meeting with Mr. Nickus, one of the things that he explained to me is that there's a scene in the movie where the actor Travis Fimmel holds his gun to the back of the neck of the child actor. He's got his finger on the trigger and he's got the gun cocked. And Mr. Nickus said, Travis Fimmel would never have done that unless he felt safe with these firearms, unless he thought that these firearms were completely safe. Well, cut to reality now. The truth of the matter is that Travis Fimmel was one of the guys who every single time Hannah Gutierrez handed him a gun, took the gun and dry fired it into the ground more than 6 times to ensure that he tested every single chamber in the gun. So certainly if part of the defense becomes these other people pointed guns at each other and it wasn't a big deal, then obviously it becomes highly relevant that these other actors felt free to do it, because whether it was their obligation under the safety bulletins or not, they understood that that was a smart thing to do, especially when you've got this armorer who doesn't seem to know what she's doing.
All right, thank you. Oh, go ahead.
Just some clarity, Your Honor, because I think it would be helpful both so we can get the court's guidance and so we can understand what kind of case they're putting on if they give an offer of proof of these issues. Because, for example, if the medic comes in and says, I had safety concerns about on set, that's an opinion about the set that wasn't communicated. It's not to say she can't say, I saw Ms. Gutierrez running around, I saw her doing this, she was moving quickly. Those are facts. We're not trying to get out facts unless they turn out to be more prejudicial than probative, unconnected to state of mind. But her opinion about the safety of the set, that should not be included. That's irrelevant.
She doesn't get to do opinion. I've already ruled out.
Exactly, Your Honor. And so what we just heard from Ms. Morrissey is, well, maybe it's relevant that an actor checked the gun on set in a different way for Mr. Baldwin, or he checked the gun at all. Maybe it's not. And so to actually get guidance from Your Honor, so we know what this case looks like when we're going into opening statement, having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent looking, I don't think I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a pending.
Lane Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nichols.
Lane Looper walked off the job,
Well,
but he didn't testify.
somebody that was like the head camera guy walked out and looked at Ms. Morrissey because we were in the case. But so if he were to testify that I left the job because of safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, I mean, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer. That's not actor. Am I being clear on that?
I'm a little confused.
Well, I'm trying. I don't know. I don't remember the scene that you used, but let me just say this. So you're saying, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez. Okay, but let's say the shooting, Sarah Zachary. Okay, when she shot, there were two, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally, I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of not my job, she was great. I had no reason to doubt.
Yes, but it has to be related that Hannah Gutierrez's
Agreed.
job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns, because that might not be related to Hannah Gutierrez.
I agree with you. It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you absolutely.
And one clarification there, Your Honor. October 8th, 9th, for example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your Honor, but that's an example.
Oh.
If a witness comes in and says on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe, that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that,
then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th that Mr. Baldwin did not see or know about.
I don't know.
Okay.
Because the other way you could do this is that he was with respect to, for example, David Halls, and how he said, well, he periodically checked the gun, and I'm not sure whether there was some kind of I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to Mr. Baldwin.
We do not want a trial within a trial.
Precisely.
That's for sure.
Yes, Your Honor.
But we also want the state to be able to address that, their theory that he should have checked the gun.
Understood, Your Honor.
Okay.
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up, and we'll ask
Yes,
for more
absolutely.
guidance when it comes up
Okay.
more
All right.
precisely.
Okay.
I think I probably stand here, Your Honor, right? We've got the next in limine
Yes, we do.
on
Okay.
inconsistent statements. Is that right?
No. Oh, yes, no. We already did the lay witnesses. This is motion in number 5, previous contradict the state's. Let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6. And
And there's 7, I believe.
no,
Or 5 and 6, I'm sorry. So
okay,
we're back
that's
to
all right.
5.
Let's see. So we're on 5. Okay. Defendant Alec Baldwin's motion limited to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief. In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker. Or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Ms. Hutchins died. It's because of Hannah Gutierrez Reed, and so forth and so on. We put them in the brief, Your Honor. Those statements contradict a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. 2 things. Number 1, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across 2 trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are 2 defendants, the government doesn't know who actually shot the gun and killed the victim. And so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case.
Okay,
that
just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said as a statement of what the prosecutor said in that case. There's a case, I thought this might come up and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. Court case or federal court, because it doesn't allow that in.
There are 2 different issues here. One is
does it violate due process to do it? And the other is, are we allowed to present the state's contradictory
Okay, so I
statements?
already
And
ruled
let
it
me-
didn't violate due process.
Right. And so on the second, and that's what the cases say. That's what Your Honor is referring to. In the case, in the Bradshaw case that the state cites in its brief, it says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation.
Mhm.
But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees with Justice Souter, says the defendant in the second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present. In fact, their own case says we're allowed to present those inconsistencies. On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they said.
Let me find this case because it went to this. But okay, I'm listening. All right.
And they say 403, but Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up in a related trial and say not X or contradicts X. And we're allowed to present that. That's their own Thomas concurrence. In the U.S. versus Small case, for example, that talks about 403 and prejudice, says extraordinary remedy. They don't cite a single case for it, and they're asking for an extraordinary remedy. And all we're asking for is that the statements that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
Your Honor, with respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. That some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized where there are cases where there are multiple defendants, as long as the prosecution doesn't present false evidence or factually or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial, and we'd ask that the court exclude any statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relate to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not, it can be dispositive on other issues, but I want to find that case. I should have just pulled it.
Your Honor, if I may.
Yes.
Two things. As a precaution, if Your Honor would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Gardenegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view. But you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that. You could find that, and it was Justice Chavez. All right. Okay, we're on. Steve.
I'm not going to repeat the whole thing all over again.
Okay, state's motion in limine 7 to prohibit use or testimony of OHSB summary of investigation.
I like it when she presents. I feel like I know her.
We have attached as an exhibit the summary of investigation that it seems clear that the defense would like to have admitted as an exhibit. So I want to address 2 issues. One, should the summary of investigation be admitted as an exhibit? And 2, should the findings, which I would argue are legal conclusions, be allowed in as testimony? So we've got the summary of investigation is hearsay. The public records exception to hearsay was never intended to permit something like the summary of investigation to be admitted as an exhibit because it contains legal conclusions. It's actually findings and conclusions. That's what they call it. It contains legal conclusions. It is based on a law enforcement investigation. That's all OSHA does. OSHA enforces the Occupational Health and Safety Act. And in addition to that, the summary of investigation, as you can see, has numerous instances of hearsay within hearsay. And while the defense responded and said Ms. Morrissey hasn't pointed any of those things out to the court, well, they're all highlighted in the attachment. So yes, it's true. I didn't cut and paste everything from the attachment into my motion in limine, understanding that we do have page limits that the court has been concerned with. I can pull up the exhibit and I can certainly go through all of the different quotes where OSHA investigators say they actually put people's statements in quotes during the investigation. So that's hearsay within hearsay. Those quotes don't come in. The findings and conclusions are legal conclusions. So those don't come in because we can't have the jury hearing that Mr. Montoya and Mr. Genoway came to these conclusions, because it's going to cause the jury to think that they now have to come to the same conclusion. The problem with the OSHA report generally is that, one, they didn't do a very complete investigation, and I outlined very specific instances of where their investigation fails. And in addition to that, every time I read the OSHA summary of investigation, I say to myself, what is the relevance of this? What does this have to do with?
But even though that's the case, OSHA gave the production the maximum fine, the maximum possible fine. That's the bottom line here. That's also why I think the producer bears responsibility in that area. The producers were given the maximum fine for safety violations. That's like a separate entity.
It's the case against Mr. Baldwin. And I want to put kind of in perspective, admitting not only the report, but testimony about the report is like let's say we're having a DWI trial and it's a jury trial, and the jury gets to hear about the
driving while intoxicated
MVD revocation hearing. That's kind of what this is, only the MVD revocation hearing would actually be arguably more relevant and possibly more admissible than the OSHA, because OSHA is not concerned largely with the conduct of individuals. As you can see, Judge, the OSHA report basically says Hannah Gutierrez didn't do anything wrong. Well, we know Hannah Gutierrez did something wrong. We did an entire trial about it, and a jury convicted her in 2 hours. So it has nothing to do with the charges against Mr. Baldwin. Now, having said that, can the state or the defense call these witnesses that were interviewed by OSHA, put them up on the witness stand? Mr. Halls was interviewed, Mr. Baldwin was interviewed, Ms. Gutierrez was interviewed, numerous witnesses were interviewed. Can we call them and put them up on the witness stand and then refresh or impeach them with the statements that they gave to OSHA? Absolutely, as long as the testimony that they're giving in the witness stand is relevant to the issues in this case. And I'll tell you, on its face, I don't disagree with the findings of OSHA. OSHA found that Rust Productions was responsible under the New Mexico Health and Safety Act for allowing this hazard to be happening on this workplace. I completely agree with them. That doesn't have anything to do with whether or not Mr. Baldwin is guilty of manslaughter. The other thing that I want to point out is the defense wants to do this thing where they don't want you to allow us to bring in anything about Mr. Baldwin being a producer. But what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed And we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death
But
was
we
the
can't
fault
say
of the
that Baldwin's a
producers.
producer.
Then we absolutely at that point get to point out that he's one of them.
Mm.
And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being
That's
a
not
producer,
fair.
and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed
What do you
because
do
they
with
go
that?
directly to the fact that he's a producer. And that will open
Seems like
up
the judge
this,
has forgotten about this.
this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, or I'm sorry, in my motion, he's absolutely a full producer. There are no limitations on his role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
Well argued. He's not happy.
3 quick points, Your Honor. Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, there's a factual finding, and it's illegally authorized.
Now, think about the, I don't know, like I may be misunderstanding this, but think about the sneakiness of this. We don't want Baldwin to be acknowledged as a producer, right? Take that out. We can't talk about him being a producer. Cool, great. Now let's bring in the OSHA report. The producers are all responsible for what happened here. Quite sneaky, isn't it?
Report, it comes in under the hearsay exception. We've cited cases on that. Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
He's not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to provide an opinion.
Your Honor, Jorgensen has no factual knowledge of the rest set. What he,
Jorgensen is the guy with the SAY guidelines, right?
that's right.
So I ruled that he gets to testify about the SAY guidelines, but he doesn't get to provide an opinion about the safety.
Correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context number. And so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Number three, just for clarity, the report didn't say the producers are responsible. It said Rest Productions LLC, that's one person's company, is the employer, and the employer, not Alec Baldwin, the employer is the one that is being fined under that report. And so there's a very big difference between saying Rust Productions is responsible for violating these OSHA rules and saying that Alec Baldwin is a producer and he had a contract with Rust Productions and therefore he's responsible. That's not all what the report said. So these are not linked in the way that Ms. Morrissey described. Nothing further.
No, Your Honor.
Okay. Court makes the following ruling. I already ruled that producer liability or whatever does not come in. So this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in and by oral and including written, then you have opened the door to producer.
Mm-hmm.
And with respect to you saying that The only reason why we may bring it up is because Jorgensen may mention it. Jorgensen's not going to mention it because I already said only safety guidelines. Okay? All right.
Okay, so don't open the
Okay, so
door
that's
to OSHA. Don't open the door.
I want to keep track of my omnibus.
You think they're gonna not open the door? That's an option that both sides have, to open their door. So in terms of the poll, do you think Baldwin is going to testify, and do you think he should? Most of you say, yes, he is going to testify and he should. I think I agree with that. Some of you say he shouldn't, 22%.
Defendant Alec Baldwin's motion in limine to preclude argument, evidence, and testimony regarding the victim.
Thank you, Your Honor. We addressed this briefly earlier when I withdrew our request to admit the medical records. It's axiomatic and not disputed that a victim's good character and all the wonderful things about them is not relevant to a criminal trial. They don't really dispute that. What they do is they try to sort of come up with ways
axiomatic
to backdoor that evidence by giving other reasons. Like they say, well, we need to explain why Mr. Souza hired Ms. Hutchins. And so
axiomatic.
Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that, to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she?
So it's kind of quite interesting. It's almost like he's saying, we don't want to talk about who the victim was. She's from Ukraine, what her backstory is. And then that against the background of who is Alec Baldwin? He has a long legacy as an actor. His beloved, whatever. Do you think that's not going to be brought up? So you negate the humanity of the victim in a way. Do you think the humanity of the perpetrator is going to be negated?
Speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant.
You don't show the position of the bodies on the ground. I think you do. It's the crime scene, effectively. And it's a very rare case where you've actually got body cam going into the crime scene while they actually still alive, both victims. It's actually very rare that you see a thing like that.
Not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else, and this is why.
Again, he wants to, please don't show the actual injury that the victim suffered. This is all about, think about it. This case is about someone being shot to death, but please don't actually show that. Don't show that the victim was shot to death. But that's exactly what happened.
I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. in the other trial in which he presided off, there was at least some testimony, some.
Do you think it's true that Helena passed away? You know, that she was alive and then she just passed away? Or did she die in one of the most violent ways possible? A bullet was shot right through her body, point blank. She's kind of just doing her job. She's in a workplace. A bullet passes right through her body. They can't move her because there's so much blood loss. They literally can't. The helicopter's there, but they can't fly her to the hospital because they're trying to stabilize her and they're struggling to stabilize her. And, you know, in the beginning, she's conscious. She says she can't feel her legs because the bullet grazed her spine. Do you think it's fair to say she just passed away? I mean, she had an agonizing death. She was fighting for her life for, I think, 2 or 3 hours. She knew that she'd been shot. She knew what was going on around her. She felt the life running out of her body. It's one of the most traumatic ways to die. She didn't just pass away. She died a violent death, a terrifying, horrible death. She didn't just pass away. And you are going to see the defense try and minimize that aspect, minimize the victim, and also probably cast shade on other people. So this is minimized, that's aggravated or exaggerated.
Indicia that they intended to proceed that way, and maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have, because it is completely irrelevant. Because I'm saying, I agree, she passed away because of this. So, and their real reasons for doing this is obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. Mm-hmm. The moment of death and subsequent pain is obviously completely irrelevant. The emotion they say in here.
Did you say completely relevant?
Irrelevant. They say that the reason that
yeah, I think he just said the victim's pain is irrelevant as well.
They're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that they say evidence is relevant and it explains a witness's conduct and bolsters. They're using emotional sympathy, drama of.
Yeah, just like you saw in the Karen Reed case. You know what? I think Suzanne Morphy did as well. That Suzanne Morphy also had awareness of what was happening to her over quite a long period of time, long enough for the chemical in her system to actually be absorbed in her bone marrow. It's actually quite a horrific thought as well.
Something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not an homicide case. It's nothing to do with it. Nothing. And to the idea that they're going to use it so that the witness is upset on a witness stand and saying, and this is how she fell, and her face was pale, and this, and now everybody's upset, and trust me, I saw what I saw about something relevant, is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with the, where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying.
Basically saying, can we not talk about how much Helena suffered? Can we not talk about what she experienced? Can we not talk about what she said? Can we not show how she appeared? So I guess you just sort of deal with the bullet goes off and then she died, and now who's responsible?
To track this precisely, again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant.
The autopsy photos are
if the
irrelevant.
court wants to voir dire the medical examiner and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person?
So how many trials involving deceased people have people said, okay, the autopsy photos are irrelevant? I was in the Mo Wilson trial, autopsy photos. Laurie Vello, autopsy photos. Actually, I'm thinking about Oscar Pistorius. I actually think they managed to get the autopsy photos excluded from that, and then her father petitioned, people need to see, and then it was actually released to the public. Her own father felt that it's important that people know what she went through.
They were going to say, of course I can't. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit, where it's like, okay, let's look at this, but I'm saying I didn't do it. This is a tragic accident where two people who are known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez retrial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that, a single witness, let alone the cumulative every single witness, which is just being done to taint the jury and to try to get the jury to do something on sympathy. Thank you.
Let's see what the judge says.
State.
How do you think she's going to rule? Oh, okay.
The state has no intention of presenting evidence related to Ms. Hutchins' childhood. So we can eliminate that right off the bat.
What do you plan on?
Well, we believe that there is limited testimony from Mr. Souza that's appropriate because jurors don't know how the film industry works. He should be able to take the witness stand and say, as the director, I got to pick my director of photography. Here's what the director of photography does. These are the reasons I picked this person. We're not going to have him talk about, she's an honest person. She's an amazing mother. She's an amazing wife. None of that's coming in. But he gets to tell, we get to put the story in context for the jury. And I think that we can do that without.
So do you hear the word that she uses, context? Is context important in a trial? Or should you have like a really narrow little fragment? Is context important?
Doing all of these things that the defense is claiming are so highly prejudicial.
Not really, Sandra. We know who, we don't exactly know what, I guess.
I have no problem limiting that testimony with regard to Ms. Hutchins, but certainly the jury gets to hear what she did, how she was hired, how does this come together? How do all of these people come together on this movie set? That's absolutely.
Yeah, absolutely. So, I mean, think about it. Do you sort of start the trial and you just sort of say, and you just sort of jump right in and you say, okay, here we are. He's holding the gun, or he's not even holding the gun. The gun's just sort of holding itself. It fires itself. Do you not provide like a mechanism of what's going on? Do you not talk about what happened earlier that day and the previous day and the day before that? And, when I covered this through a playlist of about 100 videos, I was trying to show a precedent that on this day that happened, on that day there's a complaint, on that day there was a misfire, And so it wasn't an accident, it was an accident waiting to happen. So how on earth do you not show context? How on earth do you not show how all of these cogs, because a movie set isn't, what's quite rare about this case is the amount of people that are kind of involved in the fabric of the case. Like if you think about Chris Watts, it's Chris Watts, the mistress, his wife, the kids, and maybe Nicole Atkinson. In this case, it's dozens of people, if not hundreds of people, that have a greater and lesser impact. There's something like, I don't want to get this wrong, is it 12 witnesses? There were 12 people inside the church, 12. It's not like one or two or five. I think something like 12 people, 12 or 14 people inside the church when the incident happened. And then there were people from the outside that ran in and so on. So, that whole mechanism of how it fits together is important.
Completely relevant. Now, with regard to the lapel videos, the defense says we think the lapel videos are relevant, but we just don't want the jury to see the human part of it. And that's kind of hard for the state because we kind of have to prove that a human being was killed. That's part of what we have to do here. So the other thing that you have to understand is that the defense probably is going to take a similar tactic in this regard that we saw in Gutierrez, and they're going to question all of the law enforcement officers about why didn't you do better? Why couldn't you have done this? And why couldn't you have done that?
Yeah, and so it's law enforcement's problem. It's the medical personnel's problem. They killed Helena. And so it's like, what? Did they shoot Helena and kill her? Or were they trying to save her? And counter to that is also, did Alec Baldwin, after Helena was shot, did he do anything to help her? Did he ask her, because she was still alive, did he ask her, are you okay? Did he bend over and touch her? Did he try and do anything to assist her? Right? And then you look at the other side of it and it becomes, what didn't you do? What didn't you do? What didn't you do? It's really Darvo, right? And so as soon as you minimize the injury, then you are basically interrupting the whole context where you say, okay, well, after the bullet fired, what happened after that? What was the nature of the injury? Why was it so serious? Why was it so difficult to sort out this injury? Why in terms of the response from the emergency medical services, why was it difficult? Well, because of the nature of the injury. But we don't want to show the injury. Oh, okay.
And the answer is this was extremely chaotic. We've never shown up to a crime scene where there were 150 witnesses there.
Exactly what I said.
There were people mulling around everywhere. There were things that we had to do. Those lapel videos show how difficult and chaotic that scene was, and it goes directly to their defense.
I think lapel, I'll say this under correction, but I think the lapel videos is another way of saying body cam. Could be wrong.
There's and listen, I mean, they act like these lapel videos are like a horror movie. You see Ms. Hutchins on the ground, you don't even see blood. You don't even see blood coming out of her. You see Mr. Sousa's yelling because he got shot in the shoulder. That's not overly prejudicial. Absolutely not. There is tons of case law where, and the lapel video of them laying on the ground is very, very similar in terms of the analysis as the autopsy photos. Autopsy photos come in. They do. They come in every single case. I have never had a case where autopsy photos were excluded.
Now, I must say, when the defense lawyer was saying, he said something the opposite. He said, autopsy photos are excluded all the time. And I'm like, can't really remember a case where they were excluded. In the Oscar Pistorius case, and I've actually seen those autopsy photos. I can't quite remember whether it was not allowed on camera. I don't think that was the case. I seem to remember it was the judge just decided it was too sensitive because Oscar was bawling all the time. Like you just mentioned the word blood and he'd scream and cry. And so, it was too sensitive to, and so I think that is one case where it was not allowed, but like 1 out of a dozen or more, that I've covered. And so where she says, I don't know of a single case where autopsy photos were precluded. That makes sense to me. It's really important evidence. It's what happened to the victim. You see it in a picture. What happened to the victim? Why do you need to describe it? Why do you need to, I know when I was in the courtroom for the Mo Wilson trial, in a single moment, and in a single moment, you see, and it catches you kind of off guard. You see Mo Wilson, she's not alive, she's lying on the ground, and you see her face, and she almost looks like a totally different person. And she didn't have any. I don't want to speak too much more than that. But in a moment, you suddenly get a quick, instant understanding of exactly what happened. With Mo Wilson, you can understand that she was actually she knew that a gun was being pointed right at her, and she was trying to move her face away from it. And without seeing that image, you'd have to almost try and imagine it. Why do you need to imagine something when that is giving you reality? I mean, isn't that what a trial's about, is what really happened here? But just don't show us any photos of what really happened here. Don't show us photos of the end result.
And I even cite to a case in my response where the court actually says, basically, we've never heard of a case where there was a reason to exclude these. They just come in. Now, listen, I want this court to know that during Gutierrez and during this trial, there are autopsy photos in this case that are shocking to the conscience, that we could argue.
Look at Baldwin over there. How do you think autopsy photos, because now the victim is being recognized, the victim is being acknowledged, the victim is being prioritized. And how do you think that feels for the perpetrator? If you were the perpetrator, would you want something that you did to be shown? Or would you want something like that to be hidden away, not shown? Something that you did, would you want it to be shown? Especially if you're a celebrity and it's all about how things look. Is this a good look? This person that not only is dead, but how she died, what that looked like, felt like, sounded like.
Successfully are relevant, because when you crack open somebody's body, you can see how the bullet traveled, and autopsy photos actually show that. We're not asking to get those in. We are doing exactly what we did in Gutierrez. We have just 2 to 4 very benign autopsy photos. We have been more than reasonable in terms of trying to turn down the volume on emotional response with regard to these autopsy photos. I was actually stunned to see this motion after we exercised so much restraint during the Gutierrez trial. And those are the same pictures. We haven't upped the ante here. We're not trying to show anything other than, look, this is where the bullet entered this is where the bullet came out. Those are relevant. Those are relevant to Dr. Gerald's testimony. Those come in. They come in every single trial.
I can tell you, if a juror sees that, that's going to have a very big impact. I can tell you, I've seen quite a few autopsy photos, and I can tell you how emotional it is. You feel, I mean, those images burn into your brain, and in an instant you feel incredible compassion and sympathy for the victim, but like a huge amount, you just feel it welling up, just, oh no, that this is what's happened to you, that this is where what your life has come to. And then at the same time, there's incredible anger about who did this, and that this has all been hidden away effectively, that this that what you're seeing now at last, it's been so difficult to actually see it to begin with. Now that it's revealed, you can't help feeling a surge of anger as well, that this was all so unnecessary, this wanton destruction,
Trial. There's just a reality associated with the fact that someone died. I am more than surprised to hear Mr. Spiro come up here and say, we are not disputing the cause of death. The whole reason that we have probably 4 or 5 witnesses on our witness list is because the defendant put Dr. Bianca Alvarez on their witness list. They called her, talked to her on the phone and without inviting us. And the whole point to doing that has to do with this farce defense of she didn't die of a gunshot wound. She died because she wasn't intubated properly.
Yeah, and that I think is, there's a spoiler, that I think is going to be a major strategy from the defense. And you can imagine if you're not a particularly sophisticated juror, you might go, oh, well, that's something else, isn't it?
So I want to say right now, because we're short on time in this trial, if the defense is not intending to make any arguments that she died because of a faulty intubation, let me know, because I can shave a lot of witnesses off my witness list that way.
Thank you.
Thank you.
State did not address even slightly in either their motion papers, in the Hannah Gutierrez retrial, or in that response, anything about how ashen she is or how the moments happen after matter. They don't. They didn't address it in their papers. They didn't just address it now, right? So I just want to make sure that the court, as the court was well to point out to me, demark these issues. They have not addressed that. There is no dispute that that's not possibly relevant to talk about how the person was dying and what their skin looked like and their breathing. It's just not relevant. They then go into this, how Mr. Sousa selected her to understand the film industry working. I mean, Your Honor, it's like they don't ask a single other witness, right? Well, how did you get hired, and why did you get hired, right? I mean,
What about
I'm
Hannah?
sure that the court sees through this. If somebody were to say to me, "This is the one question and answer," and there was an offer to proof, I'm sure we could work this out. But how can I possibly trust this process if we don't hear that exactly because of what I've seen? And then I'll just deal with the autopsy photos. Again, we're stipulating to identity and that she's deceased, and that we're not saying that some other causal factor killed her. So this makes the balancing test very, very easy. That doesn't happen in every homicide case, right? And also,
Did you hear what he just said? We're stipulating to identity, so they're agreeing that the person who died was Alina. That's some concession.
So, I wasn't, I don't say these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in, and often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary. We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court and has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think a second time, which is we are not making an issue out of the cause of death, period. They want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with very simple, in my judgment, balancing test. And I'd ask the court to really think about when this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons. You can't have, it's hours of testimony, hours in the Hannah Gutierrez Street trial about it. And it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony, when we have, the state has 5 days to present this case and we need the opportunity to rigorously cross-examine.
Well, that's
doesn't
not
make
a
any
lot.
sense.
Huh?
I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this this job, so to speak? And I think it's just an introductory way to tell the story. Now, I do remember Mr. Souza going into, we met, I liked her, we had things in common, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, the death. And I do think that that makes a fact more probative, and that is the death, and that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset. They talked about, how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else?
Nobody denies that the gun was in his hand. What is denied is that Baldwin said he didn't pull the trigger.
On that?
From the defense's perspective, a lot of this also goes to 403 and cumulative list, right? So
could you just answer my question? Okay.
Yeah, well, I think the answer
I don't want
is
you to
yes.
argue again. You already had your chance.
I think the
Well, do you think the judge is intimidated or kind of, what's the word, beholden to Alec Baldwin?
answer is yes, Your Honor. I'm not. If I understood the court's ruling, I think the answer is that yes. If the lapel videos are the way that they're going to show where the bodies were, or the man.
When Lieutenant Benavides is in there and he says, "Everybody clear out." Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene. That video
Right,
also
where people are rendering aid.
right.
Yeah. All right. So that comes in. Autopsy photos. Again, you can stipulate, that's fine, but they're allowed to tell their story, and they're allowed to demonstrate the death. I do remember there was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else, where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos in my mind are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez, nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death.
Yeah. That's quite a horrible way to die.
So the photos of that amount of blood go directly to her cause of death.
I will allow that. All right, I do, you can revisit that defense.
If you think about it, so did a woman die in this case? And so people are saying, can we please not show that? Did a woman die in this case? Yes. Is it okay if we don't show that? And I'm talking about inside a courtroom. I'm not saying YouTube or the media. I'm talking about inside the court, to the jury, whatever. I mean, we are not going to see those photos, and we shouldn't. The other thing that I think is so sterilized is this whole thing of, we watch movies all the time, and then suddenly you can't see a drop of blood when you're inside a courtroom. How do you think the person died? Do you think they died, like it's like turning a light switch on? And I think, and I find it in true crime all the time, it's like we are here to deal with reality. Then when it comes to reality, we just can't deal with it. We come to the end of a trial and we still can't say why something happened. We come to the end of the trial and we still can't say exactly what happened. Well, this is why. This is exactly why. Because we want to sanitize the whole thing and then at the end of it say, oh, this is what happened. No. It's not what happened. Thanks,
But
Victoria.
I do anticipate
Appreciate
you
it.
may bring up some information about the tubing.
Just to say that and I know the court has one more argument, but the court's looking at me for guidance on this. That we're not going to do that. We're not maybe going to do that. We're not going to do that. So when we say that we're not going to do that, the court can count on that, and that makes those.
Well, you didn't say that. That's not.
Oh, I thought that's what I was going to address.
You could ask the doctor. You said you didn't care about the UNM records, but that you didn't say you weren't going to ask the doctor.
If I wasn't clear, I'll make it more clear. We are not going to ask the doctor about that. So if we're not going to ask, we're not going to seek to introduce medical records, and we're not asking the doctor about that. There isn't a basis of relevancy anymore. There just isn't. And so I'm asking the court that they now have several ways the court has just allowed for them to present that this was a death, which we concede. So, right?
All right, that's fine, but they still get to do it. I'm saying no to you.
Right.
All right, so let's not do the shirt if they're not.
Stimpy, I think it's more about how culpable, not who's culpable, like the degree of culpability.
Well, no, I'm going to allow the shirt. You said that she bled to death. There's nothing wrong with that. All right.
And I'm gonna start calling off witnesses then to testify that she was correctly intubated. Are we clear that the defense is not going to raise that issue?
We are not raising that issue as to the cause of death, and we maintain our objections to the exhibits, and we understand the court's ruling.
So, just to be clear, the video, and all I'm remembering is.
So it is quite a tricky and kind of a slippery slope. If the defense want to make the case that the victim was killed by the medical personnel, then the way that the state can argue it is by showing images showing the opposite, saying, well, these are the injuries she had. In other words, before anyone arrived on the scene, this was the injury she had. This was the injury that they were, these were the cards they were dealt, right? In other words, it was a pretty fatal injury to begin with. I must say another aspect that is quite sad to think about is that she could theoretically have been saved in the sense that, if they were aware of the injury and they could have, if they had like blood bags, and if they, I mean, in hindsight, you can say if she bled to death, then the way to have saved her would have been blood transfusions or certainly extend her life. And I think they felt like there was some other injury that was worse in a way. And, obviously a gunshot wound like that, you're not going to know instantly what to do, but certainly one wonders whether, if this ever happens again, whether the emergency medical services would be able to save the next life, But I mean, you'd have to have the right blood on hand. I don't actually know whether she was given a blood transfusion, and if so, at what point. I actually just don't know the answer to that. Thanks, Robbie Robin.
The video, okay? So if there's something else that comes in about in the church, then we need to revisit this, because I am making a ruling about the video. I don't remember if there were any photos. I don't think there were photos, but I remember the video, okay? They get to put on what the church looked like. Secondly, and also that gives an understanding of where Mr. Souza was for various reasons. Then, with respect to the autopsy photos, I'm not sure whether that shirt is more prejudicial than probative. You can get out that she bled to death in different ways. I'm not sure that that's necessary. I'll revisit that.
Okay, and what I can do, Judge, if it helps, I can email copies of the photos to you so you can look at them. I mean, Dr. Gerald isn't scheduled, the photos come in through Dr. Gerald, but she's not scheduled to testify until the end of our case.
I don't want to revisit the autopsy body photos.
I hear you. I can send you,
The judge a moment ago seemed to greenlight the bloodied shirt. Now she's flip-flopping on that.
I apologize. I understand why I just got my wires crossed. Some of the photos of the bloody clothes were taken by OMI. So what I can do is I can email to you, and of course CC the defense, those photos of bloody clothing so that you can look at them and you can make a determination long before the witness ever takes the witness stand, what's appropriate and what isn't. Understanding autopsy is something different. You've already ruled on that.
All right, thank you for that.
Your Honor, if we may go back to the state's motion, defendant's motion on limine number 5, I found the case that the court was referencing.
Okay, what is it?
It's State versus Montoya. It's 2016 Westlaw 3639984. It is a Justice Chavez opinion, and the issue begins in at paragraph 42 and 44, where the court did not allow the defense to introduce the prosecution's opening statements or statements during opening in a previous trial.
There's two State versus Montoyas.
So I think it's maybe important that I clarify, when I write a book, when I make a YouTube video, I kind of have the approach that I'm the prosecutor. I'm prosecuting the reality of what's going on. What is the evidence? What does the law say? All that kind of thing. And, I do think you get some people that gravitate to the defense side and some people gravitate to the prosecution side. I definitely do gravitate to the prosecution side. Like at this point, Helena's death has not been fully dealt with. It's sort of been half or a third of the accountability aspect has been settled. And so it still needs to be prosecuted, it still needs to be sorted out. That is not the position that the judge takes. The judge is going to try and balance the interests of the prosecutors and the interests of the defense in a way that's fair. So the judge is trying to listen to the points raised by the defense and listen to the points made by the prosecution and kind of somehow find the middle ground. Well, that's not necessarily just the middle ground. It's also what's fair and legal. I mean, she is educated in the law, so that's another aspect. But nevertheless, she's trying to make it a fair trial. She's not trying to give the prosecution everything that they want or the defense everything that they want. She's trying to give to both sides, but also have respect for the law. And so that's really what's being balanced here.
Yes, Your Honor, this one is, it's a Westlaw site.
Oh, I see. Okay.
It's 2016 36399. Oh, sorry, I just lost it. Let me go back. So it's 2016 Westlaw 3639984. And it's Justice Chavez' opinion.
And Your Honor, we can take a look at that in the break as well and give you our views, if we may.
Mm-hmm.
Thank you.
Just wanted to see if it was the one I remember. Okay.
I don't know if that was the reference to opening statements.
That was the next one up.
All right. State's motion in limine 8 to allow use of exhibits during opening statement.
Your Honor, we don't have I think there's a way to shortcut this, which is that as long as the defense can also put in exhibits and the court will, if there's any issue between the two sides, address those one or two issues. I'm hoping that there's not. We would not, as long as it's equal to both sides, we would not have an issue.
Are they going to be admitted?
Yes, Your Honor. In fact, I provided defense counsel this morning a copy of the exhibits. I have a copy for the court if you'd like to look at them. What I would request is that they provide us today with a copy of the exhibits that they intend to introduce in
All
case
right.
there are
But do
any
you
issues.
think there's going to be an issue on admission at trial?
No, Your Honor.
I don't believe there's of the exhibits that we're putting forth. We're putting forth basically the same set, a little bit more of a videotape or a little less, and the 911 call. That's it. So there's very few exhibits that we're using in opening, and I don't think any of them are an issue.
All right. Well, I want you all to agree because I do not want us to stop in opening statement. Okay?
Yes, Your Honor.
So if you don't agree, let me know.
Yes, Your Honor.
All right. Defendant Alec Baldwin's motion limited to preclude argument, testimony, and evidence related to the incident from the Crow.
Thank you, Your Honor. We move to exclude the state presenting evidence of what happened on the Crow as evidence of Mr. Baldwin's state of mind here. The state has said it will not present evidence of what happened on the Crow, but what the state did say is it intends to address and present the theory essentially from the Crow that blanks can kill. Mr. Baldwin knew that, and therefore he's responsible for having the criminal state of mind necessary to prove involuntary manslaughter here. There are 4 problems with that, Your Honor. The first is, let's go back to the indictment. The indictment says that Mr. Baldwin is being charged because it was foreseeable to him that if he didn't check the gun for live ammunition, it says nothing about blanks, not a single word, then his use of the gun by pointing it and pulling the trigger, they allege, could cause significant risk of harm to human life. That was the theory of the indictment. Live ammunition, nothing about blanks. A few witnesses mentioned here and there blanks in the context of an accidental discharge. They get loud, you have to put your goggles on, your earmuffs on, people get mad. There is no testimony in this case about that blanks kill in this particular situation. The case theory has always been, they've said it over and over and over in the papers they've submitted to you, Mr. Baldwin didn't check for live ammunition. He pointed the gun, he pulled it, and then Miss Hutchins died. So they're trying to vary significantly from the theory of the indictment. Problem number 2, causation. Mr. Baldwin not checking for blanks and then pointing the gun did not kill Miss Hutchins. She was not killed by a blank. She was killed by a live round. And all the testimony shows that blanks are very different from live bullets. If Mr. Baldwin checked for a blank, there would have been no blanks there. And so they have a major causation issue as a matter of law in presenting this brand new theory that was not in the indictment. Number 3, there's a foreseeability problem as a matter of law with their intention to present the blanks theory. The Henley case, as Your Honor knows, we've briefed it for you, says the requisite criminal state of mind needs to match or converge, is what the case says, with the criminal act. And what the state's doing here is they're playing apples and oranges. They're saying Mr. Baldwin had the reckless criminal state of mind because he knew that blanks can kill. That was foreseeable to him. He didn't check for blanks, and then Miss Hutchins died. But the act that he's been charged with is not, he didn't check for blanks and Miss Hutchins died as a result of a blank. It's that she died as a result of a live bullet. So they're mixing apples and oranges here. They're trying to take what they say is a foreseeable risk and match it with an act that didn't cause the death. So that violates the very clear requirement of Henley that the state of mind and the act converge. That's not what they're saying here. And then last but not least, there is zero evidence in this case, zero, that Miss Hutchins would have died, or it was expected that she would have died, if you look at the foreseeability cases, if there were a blank in that gun. The foreseeability cases say it's not what can conceivably occur. Blanks can kill. It's not what can conceivably occur. It's what's expected, what's objectively and reasonably expected. There's zero evidence in this case. They don't have an expert. They don't have a fact witness that can testify. Certainly a fact witness wouldn't be allowed to testify about this, that if Mr. Baldwin had a blank in that gun in that moment, it would have killed Miss Hutchins. Zero. There was no obstruction in the barrel. They keep on saying obstruction in the barrel. There was no obstruction in the barrel. He was feet away, 2 feet, 3 feet, 4 feet away from Miss Hutchins. It was pointed at her armpit. There's nothing in that gun that could have pierced her body. There is zero evidence. If you look back at The Crow, if you look back at the history of motion pictures, there are 2 incidents where a blank was involved in a death on a movie set. In 1984, an actor put the gun directly against his head and the pressure.
Sorry, I see I'm muted. We want to provide the history of motion pictures, but we don't want to provide the story of this human being, right? What I said earlier is I really didn't understand what he was getting at there. I think he was talking about another movie, The Crow.
Pulled the trigger, and the pressure from that directly against his head killed him. In The Crow, so very different from what happened here, miles and miles and years apart. Number 2, in The Crow, what happened was the crew was making dummies out of live bullets. And when the dummy was put in to the gun, it still had residual gunpowder. And the primer got hit, it knocked the bullet tip off, it discharged. And
now, that's quite an interesting point, because I think in this case, you also had something like that taking place, that Thel Reed, wasn't he making live rounds out of dummy rounds? And I mean, if you think about that, there's a recipe for disaster. Taking a dummy round and making it into a live round, what could go wrong?
And then there was a blank loaded behind that live bullet tip from a live bullet that people on the set were making improperly. Still no criminal prosecution there. Said it was civil negligence, not criminal, but that's not the point. The point is, if you look at what happened in both of those cases in the history of motion pictures, they are entirely distinct facts. The state cannot come in at the last minute and say, blanks can kill, Mr. Baldwin knew that, and therefore he had the requisite state of mind, and they match it up with an act that killed Miss Hutchins. Zero evidence that that would have happened here, and therefore they...
I do think you've got to look at the incident in The Crow where there wasn't a prosecution, and this incident, and I think you've got to look at it and say how they are similar and how they're not. And I can tell you one big difference is that on the morning of the incident in the Baldwin case, you had 6 members of the camera crew walk off because of safety concerns and other concerns. That didn't happen on The Crow. Also, The Crow wasn't a cowboy movie. This was, and you'd expect proper protocols with firearms at a much higher standard in a firearm movie where there are lots of firearms going off all the time than where a firearm goes off arguably once in that film.
They cannot present it as a theory when there's no causation for it, there's no foreseeability for it, there's no evidence for it, and it's not in the indictment.
All right, thank you.
Thank you, Your Honor.
I'm looking at the indictment that was filed in this case. I don't see anything that says live round. I have it right in front of me. So I'm not exactly sure what Mr. Nickus means when he says if you look at the indictment, he was indicted for that. I'm looking at the indictment. It doesn't say anything about that. So I want to try on occasion to agree with the defense. I want to try to come together. The issue of, do we want to have witnesses testify about what happened on the set of The Crow? No, of course not. I intend to present absolutely no testimony with regard to, I expect no witness to say The Crow. But here's why this is relevant. The entire defense is Mr. Baldwin had no reason to believe that there was a live round on set. Well,
Is it on set or in the gun?
I think they've argued both. They've argued that he had no reason to believe that there was a live round on set, that he had no reason to believe that there was a live round in the gun. So, and here's what they're going to argue. They're going to say this gun is completely inert. He should be able to treat it like a toy because everything is completely safe. Yeah, but the problem is that these safety bulletins and these rules that the defendant failed to follow were created because real guns on movie sets are dangerous. That's the whole reason they...
She's almost explaining it like it's to a 2-year-old. But I mean, that is the point. Those rules are there to prevent what just happened here.
Were created. And one of the ways that
if you think about it,
dangerous is...
Sorry, if you think about it, when you get onto a airplane, and I mean, I think I counted, I was at 10 airports when I was in America. Every single time you get on board a plane, you get the safety protocol, right? Because there's a risk aspect when you get on a plane that it might fall out the sky. There's a risk that you could lose your life, and it's part of the law and airline safety that you try and mitigate the dangers, right? And so you have all of those things in place. Now you don't just go, yeah, we know what those things are. Let's just get the plane in the air. And then what happens if something does go wrong when the plane's in the air? What if some of the airline crew walked off because they said, well, we don't like that, and that wasn't done, and that wasn't done, and then the engine does blow up in the air? What then? And so it very much is like that. Those protocols are there for a reason. A movie set's not the same as you in your home. A movie set's not the same as Chris Watts in Frederick, Colorado, or any other case. A movie set is its own ecosystem, and it's got its own rules and protocols, and you've got to honor that. You don't just go, okay, well, it's just, here I am, and someone did this. It's pretending that that's not the case when it is. And it's also, when you get onto a plane, those safety precautions apply to everyone. They apply to people in first class. They apply to economy. They apply to the crew. They apply to everyone. You don't say, well, I'm just an actor, or I'm just a pilot, or I'm this or that. The safety stuff applies to everybody.
Is because if you combine a blank with a barrel obstruction, you can kill someone. It's not what Mr. Nickus said, that there's no reason to think that it would have killed anyone. It would have killed her if there was a blank and a barrel obstruction. I agree with him that that's not what happened in this case. But the point is, real guns are dangerous. The SAG safety bulletin from the Screen Actors Guild says blanks
Hey,
can
Liesl.
kill, underlined, bold, exclamation marks. Mr. Baldwin's state of mind is what's critical in this case. And Mr. Baldwin,
I don't really like seeing this sort of commentary that it could be a hit. What is this, a conspiracy? I don't really like seeing that. Are you new to this case that you don't really understand what's going on?
Baldwin understood real guns on movie sets. Even best case scenario for him, we imagine that there's no chance that there could be a live round on set. He still knows they're dangerous, and he understands that the rules exist because they're dangerous. The rules that say, don't point it at anyone, keep your finger off the trigger. Those are all the things that were designed because real guns on movie sets, even if there's not a live round, can kill people. Mr. Nickus can stand up here and say blanks don't kill people. They certainly do kill people. And the Screen Actors Guild Safety Bulletin says blanks can kill. So the problem is that the defense theory is this was a completely inert gun. And the only thing that made it a problem was the fact that there was a live round in it. And that's simply not true. And it goes to Mr. Baldwin's state of mind. It goes to exactly what the state has to prove.
That's quite a big reaction.
He knew or should have
Big
known
exhaling of
the
breath
risk when he pointed the gun at someone, cocked it, and pulled the trigger. Live round or not, he understood that risk.
Is it true that that goes to his state of mind? Because some publications described him as horsing around. When someone is horsing around, is something going on with their state of mind?
That's what we have to prove, and that's what we're going to prove.
Well, it was in the grand jury hearing that the indictment doesn't say it, but
Sure.
You did to get the true bill. You talked about live ammunition in a gun.
Sure, absolutely. And that's certainly a part of this case. And I don't want to pretend that it isn't. Because the other thing that we know, and we put this in some of our responses, is that when Mr. Baldwin was being interviewed by Corporal Hancock, he actually said to Corporal Hancock, I'm wondering.
Okay, so how can you say it could be a hit? So, sorry, who's supposedly assassinated here? Helena or Alec Baldwin? I don't really even if you're saying, well, I don't think so, then why would you bring it up?
If Hannah commingled live rounds with her dummy rounds. He knew that there was a possibility that a live round could find its way on set. He didn't even know that Ms. Hutchins had died yet, and he told Corporal Hancock, I wonder if they were commingled. He knows that these guns are dangerous. And listen, the state isn't, I've had countless cases where the prosecutor has a slightly different theory at trial than they did in front of the grand jury. There's nothing improper about that. We're not amending, we're not trying to add charges at the last minute. I don't understand exactly what the issue is. If there's case law that says that I'm married to absolutely every single theory that was put in front of the grand jury, it's news to me, because I've had courts amend grand jury indictments in the middle of trial based on the evidence. And the evidence in this case is that this gentleman knew that you can't point a gun at someone and pull the trigger, because even if there's not a live round, it might kill somebody. He knew that. And I agree, we don't have to get into what happened on the Crow, but at the same time, the safety bulletins are made because of that. They exist because of that.
Thank you.
Few issues, Your Honor. In terms of the indictment, it was in the grand jury instructions on which the indictment was based, to be clear. There's nothing in the grand jury instructions, the indictment in this case, where the actual allegation of the charge is that Alec Baldwin didn't check for blanks, and therefore he's committed involuntary manslaughter. This, in terms of time, Your Honor, and sensitivity to cumulative witnesses and cases within cases, this is a case within a case. It's a hypothetical case about an act that didn't happen, that didn't cause the death at all, with, on top of that, significant questions about whether it's even possible when we know from the history of motion picture, it's never happened in this way. Who are they going to testify? Who are they going to have testify? The state, that Miss Hutchins would have died if there were a blank in that gun. What expert witness is going to say that? They don't have a single expert witness. They don't have a single fact witness who's allowed to testify about that. They don't have any evidence that there was an obstruction in the gun.
I don't really know why they even going down this path, because there wasn't a blank in their gun. There was a live round. So why even? It's hypothetical. Why even going down this path?
There's literally no evidence of this. And if they want to put on a theory that merges different state of mind with this hypothetical act that didn't cause a death, then we're going to have a very confusing trial with multiple different witnesses being asked, have you ever been on a movie set where a blank killed someone? Have you ever been on a movie set where a blank shot and pierced someone's body in a way that was really dangerous? Have you ever had someone on a movie set shoot a blank in a way that did anything other than cause a little rash or hurt someone's ears or make their eyes have stars in them? We're going to have a trial within a trial about a hypothetical that was not raised until the very last minute. It wasn't the basis for the charge in the first place. They have foreseeability issues. They have causation issues. They have evidentiary issues. And there are major notice issues. And in terms of cumulative testimony and wasting of time in cases within cases, that's what this theory is going to become. Thank you, Your Honor.
All right, thank you.
So a really interesting aspect to this is Hannah going to testify? Is Hannah going to testify for the prosecution? Is Hannah going to testify for the defense? Is she not going to testify at all? As far as I know, she's not been offered immunity. So I don't know. I kind of get the feeling she's not going to testify.
All right, the court makes the following ruling weighing whether it has any tendency to make a fact more probable or less probable than it would be without it, and whether its probative value substantially is outweighed by unfair prejudice. I think it's difficult to deal with what I read in the grand jury transcripts about, the theory about the negligent use of a deadly weapon is just his manner of handling, that he shouldn't have cocked the gun, et cetera, et cetera. And then with respect to the alternative, it is that he failed to check the gun. He failed to confirm that the gun, I remember the word confirm, about live ammunition and, before he pointed it at someone. I think that I will not allow any testimony other than one sentence statement, probably by your expert, Ms. Morrissey, that says that blanks can also kill. But to consider that he failed somehow, that's just going to be up to the trier of fact. I think everybody knows guns can kill. It depends on what's in there, but I think that you can mention it. But that's it. We're not going to go through 5 different questions on tell me how and how serious this is, and if he's a gun owner and he's done all these westerns, or not westerns, but all this gun experience, and he should have known it. Just say that, and if you can tie that up, great.
Understood.
All right, let's take our lunch break. Okay. All right. What else are you going to surprise me with? Exhibits? What are you going to do? I mean, because maybe we can have an hour lunch.
I want a real exhibit list from the defense that doesn't list
You
every
don't-
piece of evidence.
They probably feel the same way.
Well, we were pretty specific.
I do think that given the court's guidance today, that there could be, I'm hoping that the opening exhibits all work out, and I'm hoping that this slowly streamlines the board.
The voir dire is 50 minutes max a piece.
You said 50?
50.
Okay.
50.
And
Oh, let me just be clear on voir dire so as you're getting ready for it. Questions. I know I'm looking at you, but he's standing. Questions, not just keep standing. All right, no, okay, you can sit down. Okay, questions, not your theory, your hi,
Nice
how are
shoes.
you? You know, questions, okay? And the issue is fair and impartial, okay? Not maybe this isn't the case for you. We're not shopping. It's fair and impartial, okay?
Yes, Your Honor.
And questions.
I'm
I'm emphasizing questions. You ask questions. You don't talk to them. Do you understand what I mean? I mean, I'll give you latitude, but I'll have to pull you in if you're not trying to get fair and impartial.
I'm just wondering in terms of what sent us into individual voir dire during.
I'm not going to do individual voir dire.
Okay.
I think this is different.
And I'm just.
Well, I'll hear you out. Okay, I'm sorry to interrupt you.
No, and listen, it may not turn out to be an issue, but my only concern is if we start to have potential jurors who say, I don't think that I've seen in the press that he didn't know that the gun was loaded, and I don't think that he should be prosecuted. I think that there was a concern in Gutierrez that if we have all of these jurors just giving their opinions because they've seen things in the press, it kind of poisons the well.
Right.
So
Well,
that's my
first
only
of all, my intent is, and I'm open to hearing from you all, but when that happens, I'm just going to call you up and agree that this person should be stricken for cause and he can leave. What do you think?
Sure.
Yeah, it would have to depend on the, how extreme it was, but I think we'll be able to
Right.
make eye contact, frankly, and figure out some of this. Yeah, I don't know how the court, I wasn't there at the first trial, and I don't know how the court is planning to design this. There is, of course, in both directions, a risk of pollution of the jury pool, right?
Right.
You know,
Yes,
so
absolutely.
So I think that if anybody has, extreme views on anything, maybe that's a way to sort of say that you're going to hear questions. And if you think that you have a view that should not be spoken publicly and you
Sure.
would like to speak to me
Right.
and the lawyer separately,
Right.
you can so indicate.
So how do you deal with the jury? Do you like Alec Baldwin? Do you not like Alec Baldwin? So I guess you kind of want someone who is kind of somewhat indifferent. I think that you had a similar situation in the Trump jury, basically someone who doesn't not read the news, someone who doesn't really watch movies very much, doesn't really know much about Baldwin one way or the other.
When
Right.
you raise your hand.
Right.
And
Well,
that-
that's part of my instruction.
Right.
Okay, that you can speak in private. And most people start saying, well, I want to speak in private. Or you say, do you feel
But how many Americans don't know, in the same way, don't know Trump, don't know Baldwin one way or the other? How many Americans would be sort of, who's Alec Baldwin?
like you should speak in private? And they'll say yes. I'm less inclined to do private voir dire because it just took so long. And the other thing is that, think about it. I think we're going to have 79 on the panel, and we will be able to know immediately. You're going to get 5 and 3. Is that right? Yes,
Yeah.
5 and 3, and for causes, and we'll know whether we need a second jury panel by then.
I just want to throw this out there. One of the things that may speed up the process, if we do have a juror and we think that they may have some potentially prejudicial things to say, rather than kicking everybody out of the room, maybe we can just invite that person
Yes,
up
so
to the
that,
bench.
I've done that. Yes, I've done that.
Okay.
I agree that makes sense.
Okay. Was anybody thinking private?
I just wasn't sure.
I think it's easier to do the subset of private when necessary and not invite it at the start. The judges that I try cases in front of always think that if you invite it too early, then it becomes a domino effect. I'm just repeating what other
No,
jurors have said.
I expect a lot of folks will want to speak in private about this, but I just, I think this is different, a little different from Hannah Gutierrez.
And will we be addressing the entire group or just?
Yes, 79.
You'll do the whole group in our questioning?
Yes, and then if you can't pick a jury out of 79 folks, which I find highly doubtful, then we'll call in the next panel, okay?
Thank you, Your Honor.
And does the next panel come in that same?
Staggered, yes, it's staggered. That's why when we're finished with the 79, I want to know if I have a jury.
Okay.
So, yes, I want to know how many, and we'll know probably by the 4 causes.
Understood.
Okay. All right, well, and so do you want an hour for lunch, or do you,
So the only thing that I would say about the exhibits, and I mentioned this before, but perhaps we're getting even further, which is, I've just told them about one part of their case that's not going to be necessary, and they disclosed when that witness would be testifying. If the state can even provide some shell, okay, right now we have still have 44 witnesses and 13 experts. Any guidance, I'm not holding them to the guidance. The court need not. I'm not going to ask the court to hold them to the guidance of the gist of the case. The gist of the case and their expected witness, we are going to be able to very, very quickly say, okay, then those lapels, that issue, it becomes irrelevant, and I'm going to be able to deliver to the state what they're going to ask the court for.
okay, very good. So what we're going to do is we're going to take an hour lunch because we're almost finished with these. And then the court is going to instruct you all to meet and confer about what you all think about your cases and streamlining. Okay? All right.
Thank you.
All right, we're in recess.
Okay, we are in recess. Alec Baldwin's got a nice little bag there, got his yellow legal pad. I've also got mine and mine. Have you got yours? I wonder where his wife and kids are. Are they going to be in court for the trial? So Liesel, someone made the comment: are kids allowed in court? What do you think of that? Are kids allowed in court? George says, so this judge is going to decide if there's a case here. No, that's not the case. They're basically going through voir dire and also jury selection and pretrial. It's the pretrial phase. The judge doesn't determine that they've already decided that there is a case. Let's have a look at your comments. Shannon says, I've never seen kids in court. I've got to say the same thing. Yes, as a general rule. Yes, as a general rule, what they are allowed in court. Well, why would Baldwin want his children there? Because it humanizes him. He's a dad, he's a family man, the poor kids, if he's taken away from them, how they're going to cope with the ravages of life in Manhattan. All right. Liesel, do you think Baldwin's kids or his wife will be in court? I can't imagine that they won't. Certainly, you'd think that his wife will be in court. Hilaria, right? So I'm not going to cover the afternoon session. I'm barely holding on as it is. I'm just extremely tired. It's my bedtime really now, so I'm going to be turning in. Does he have any kids over 18 years old? Yes, he does have one. I think her name's Ireland Baldwin. So she's a mom and so on. So we'll see how far everything goes today, and maybe the trial proper will start tomorrow. I guess we'll see. Yeah, it's hard to say. Liesel, do you think they're going to have a jury by the end of today? I can't think it's going to be that difficult. Yeah, pull on heartstrings. Charles says kids are in court if they're a victim of a crime or a witness. Well, or presumably if they family members. The trial does start after jury selection. Okay, guys, thanks a lot for being here. I'll obviously be here again tomorrow, same time, same place. And yeah, it's not a really long trial. It's about 2 weeks, so should be short and sweet. And hopefully we'll get at least a verdict in this case compared to Karen Reed. I think, I don't know, the fact that Alec Baldwin is who he is may have a bearing. Of course, if you think about it, Karen Reed was kind of turned into a celebrity. So maybe there is a possibility of a hung jury in this case. And maybe that's also why the judge took out the whole producer role. She's trying to make things as simple and as straightforward for the jury as possible. Anyway, that's it from me, guys. Thanks a lot for being here. I'm going to bid you guys adieu. Thanks very much for the super chats. Robbie, Robin, Christine, Webb, Victoria, Earth, Pauline Buckles, Faticus. Thanks very much. Appreciate it, guys. I'll see you guys tomorrow. Take care and have a good rest of your day. Ciao.